Kurt O'Keefe, Michigan bankruptcy attorney in the backyard of World Headquarters. Another video on aspects of bankruptcy law, especially as they apply in Michigan, where I practice. And the question I'll talk about today is, what happens to my house when I file bankruptcy? If I file, well, there's nothing that automatically happens just by virtue of filing for bankruptcy. Chapter 7 liquidation bankruptcy case. If you want to keep your house, you have to keep paying for it. If that mortgage company filed the right papers in the county and perfected their lien, they have a lien on the house, and a lien is not wiped out by bankruptcy. Your personal liability can be wiped out. So in Chapter 7, if your house is worth the mortgage, no more than the mortgage plus the exemption that you get, you keep making the payments, keep insurance, pay the property taxes, then you can keep that house. If you do not want to keep a house, you're free in Chapter 7 to let that house go. The creditor can come after it if there's no equity, no value, that isn't exempt. There's a trustee appointed by the bankruptcy court in Chapter 7 cases who would be entitled to any equity that isn't exempt. So it's your choice. So the Chapter 7 or liquidation bankruptcy doesn't mean that you lose your house. Now, if you're behind on the house, if you don't make the payments, eventually that mortgage company will be able to foreclose and take the house back. Chapter 13 is a payment plan bankruptcy, or Chapter 11 payment plan bankruptcy. But again, there's nothing that automatically happens to your house. It involves what are the facts of your case. Are you current on the payments? What's the value of your house? And then your choice. You can't be forced to keep the house, but you won't be able to keep it under current law without paying your first mortgage as it's written. That is, the bankruptcy courts do not have the power now to change the terms of the first mortgage on the house in which you live. Now, they can do things with the second mortgage or third in Chapter 13 cases. Chapter 7 case is not wiping out any liens, and if you want to keep a house after you file your Chapter 7, you'll have to pay whatever mortgages there are on it, as well as other charges that may be there, like taxes and water bills. And you'll have to comply with the terms of those mortgages, or they will be able to foreclose, maybe not during the bankruptcy without a court order, but after the bankruptcy, after the stay is lifted as to the property. So those are decisions, and you can change your mind. I mean, a 13 case can be converted to a 7. Chapter 13 plan can be a 5-year plan that's confirmed by the court, but they're voluntary. So if you want to pull out of a Chapter 13, you can do that at any time. So you may have the decision that you're filing a Chapter 13 because you want to keep that house. I've had some cases, unfortunately, recently where clients of mine successfully completed 4 or 5-year Chapter 13 plans that they filed to stop a foreclosure and catch up on the house, and they get to the end of the case, and now because of the declining real estate values in Michigan, that house is worth way less than they owe on it, and at this point they don't want to keep the houses. So there's nothing automatic that if you file Chapter 7 you lose your house, or file Chapter 13 you keep your house. It's something you'll have to work on and figure out accurately as best you can. What is the value of your house? What are the amount of mortgages and taxes and any other liens owned on that house, so that you can plan that with your bankruptcy attorney.